While few of us want to consider the end of life, it is one of those inevitabilities, regardless of how we feel about it. Most of us want to be assured that after we are gone, our loved ones are protected. Having a will is one way we can do that. A will is an essential estate planning device. Regardless of your age or your financial means, having a will can help protect your assets and your family should the unforeseeable happen. The importance of having a will in estate planning. Having a will, also called a last will and testament, is important at any stage of life when you have family or assets of any kind. A will enables you to leave property to people or organizations of your choice, establish a legal guardian for your minor children, and name a trusted executor to oversee the distribution of your estate after your death. While simple wills can be practical for most estates, the law also allows for the creation of wills that can help with tax planning or include built-in trusts. Without a legally valid will in place, your estate may go into a long probate process and the state will determine how your property is distributed. Through probate, the state will also decide who will care for your children, and any other matters concerning your estate when you die. Having a will ensures that your estate is distributed in the way that you want, not in accordance with the laws of intestacy. With a will in place, you can have peace of mind knowing that your property will be distributed and your loved ones will be cared for in a way that you would want should the unexpected happen. What happens to your property if you die without a will in Houston, Texas? Under the law in Texas, if you die without a will, you will have died, intestate. Your assets will be distributed to your spouse and closest relatives based on state laws. Intestacy laws in Texas distribute property beginning with your spouse and your children, then continue with parents and grandchildren until more distant blood relatives are exhausted. If no living relatives can be located, then the state may have the right to take your property. While intestate succession has been designed to consider the closest family members and children first when an individual dies in Texas, it doesn't provide for an individual's specific wishes. You may want to leave part of your Texas estate to a close family friend or an organization. You may wish to have a close family friend as a guardian to your children. But these choices will not be considered by the court unless there is a valid will in place. What happens to your minor children if you die without wills in Houston, Texas? As a parent, one of the most important responsibilities we have is planning the well-being and future of our children. However, if you die while your children are still minors, without wills or trusts in place, Texas laws will also determine who will care for them when you are gone. Under the law in the state of Texas, should you die without a will, your minor children will be raised by the surviving parent. But what happens if both parents are no longer alive in Houston? The law regarding state intestate succession will then look to a grandparent. If more than one grandparent is still alive, the court will make a determination based on what they feel is in the best interests of the child. If no grandparent is alive, then the courts will consider the next closest living relative. Family relations can be complicated, especially under the law. You may not have wished for a relative to be the guardian of your children. There may be family members you would not want your children to be raised by or would provide an environment that you would not want for them. But without a valid will in place, intestate succession laws in the courts will make these determinations. Especially when you are the parent of minor children, a will is critical to ensure the care of your children should something happen to you. Naming an executor of your estate. Naming the executor of your estate is one of the other important considerations of a will. Your executor should be a trusted individual who will be responsible for carrying out the responsibilities of administering your estate. If you die without a will, the court will be required to name an administrator to carry out these duties. This is often one of your primary heirs based on intestate succession. Unfortunately, without a valid will in place, the court cannot consider your wishes, and your executor may not be someone you would have chosen. This is why it is important to speak to a skilled attorney when planning your estate. The importance of a legally valid will. While there are many online options for creating a will, a legally effective will is more than filling in a simple online form. If your will is not drafted and executed properly, it may not be recognized by the probate court after your death or may result in disputes between family members. A will is a legal document that carries out essential estate matters after your death, and its contents are important. Each state has specific requirements that a will must meet in order to be legally enforceable. As your will passes through the probate process, it can be challenged if there are questions regarding its validity. Having a skilled Houston wills lawyer draft your will ensures that all legal requirements are met and all financial and estate matters are considered. Updating your will. Life changes, and so should your will. You should revisit your estate planning documents anytime there has been a birth, death, divorce, or other important change in your life or your family. Speak to a skilled Houston estate planning attorney. Your will is a valuable estate planning device that allows you to choose how your property will be passed on after your death. But many individuals put these important matters off for someday. If you own any assets, you want to be the one who decides how they will pass to others once you are gone, not the state. Making a will is a simple step in ensuring your wishes will be considered. Estate planning can be simple or complex, depending on the unique needs of each family. It is important not to leave these matters to chance. At the law office of Whitney L. Thompson, we take the time to understand your wishes and needs so you can rest assured that your property will be passed to your heirs the way you choose. If you have questions about an existing will or would like to have a will created, call us at 281-214-0173, or contact us through our online contact form to schedule a consultation.